Just a quick disclaimer, I'm not giving any legal advice per se tonight. I'm not establishing an attorney-client relationship with anybody. Because I'm a lawyer, I think it's important that I say that. Anytime you have increased drilling activity in an area, what you see is the permits go up. This is a timeline from 2004 to 2012 in Canadian County. And you'll see the permits went from nearly nothing in 2004 to, almost 230 in 2012. And that's what we're looking at in this area of Carter and Love County with all the activity that's here. We can expect this kind of activity in the coming years. So the outline of today's presentation, I'm going to talk about the basic discussion of the philosophy of an article I wrote called Don't Give Away the Farm. And basically it's the idea of if you're going to enter into one of these negotiations, define it well. And as they want to move out of the parameters of where you've defined it, make them pay for that. So if you set a specific time frame of when they're going to be able to apply the mud, also set a specific amount of loads that they can apply, and if they want to stay there longer or they want to apply more loads, make them pay more money. It's real important to get strong terms. I always say it's a battle of the terms, and that's really what I think all these negotiations are about. If you decide to do this, is make sure that you don't sign something that's real broad and just lets them kind of come in and use your land however they want, and they kind of set the rules. You need to set the rules yourself. I'm going to talk a little bit about the statutory framework allowing the application. We've heard a little bit about that tonight. I'm going to get into just a little bit more specifics about it, but I'm going to go through it pretty quick because part of that the first presenter covered. And then I'm going to go over a brief overview of the potential benefits and risk, which we've heard a lot about that too. So I'm going to go through that pretty quick. And then I'm going to go over what needs to be in a good drilling application and surface use agreement. That's kind of the heart and meat of the presentation, and I'll probably slow down a little bit when I get to that point. This is an article I wrote called Don't Give Away the Farm, Negotiating Surface Damage Cases. It was published in the Bar Journal. It's on my website. If you're interested in negotiating with an oil company, I'd encourage you to go out online, read this article. It talks a lot about the mentality of negotiating with an oil company and the way that you think. To me, it's all about how you think when you're negotiating with one of these operators. They always want to frame the rules, and they always want to say, well, this is how the oil company does things. Well, it never made sense to me why a landowner can't say, well, this is how things ought to be done. It is our land, right? So the possible benefits, I've been told that soil farming can improve the water retention in the soil and that it can, in certain situations, improve soil fertility. Our first speaker tonight could tell much more about this than I know. The main one, I think, is that it can provide supplemental income. Folks that are in agriculture are always looking for creative ways now more than ever to create supplemental income with recreational use of their property. This is just another way to generate some supplemental income, and if done properly, it can work really good. It can also be good for the relationship between the landowner and operator. Many times when, an operator comes and they're drilling on a ranch, it's tense because the surface owner may not own the minerals, they don't want them there, but a lot of times that it can be a real win-win relationship between the operator and the surface owner because the surface owner can sell water, they can allow soil farming. So soil farming is just another way to kind of improve the relationship with the oil company, and if done properly, it can be a real good thing. The risk, salinity, the city, pretty much all the things that we heard the first presenter talk about tonight. These are the things that we have to think about. So any contract that we enter into needs to somehow talk about these risks and how we're going to deal with them and how we're going to define them, what's going to be allowed. This is just another picture of, a piece of ground that's got a lot of salt in it, and when it gets a lot of salt, it doesn't want to grow grass, and most of us are in the business of growing grass. So we're going to be trying to grow grass for the next 30 years, and that's one of the things you need to evaluate is what's it going to do to my grazing capacity on my land if I allow them to come in and pay me so much an acre. It may not be worth it, especially if it's not done properly. He talked a little bit about toxins and metals. This is a risk, but I guess it's a minor risk compared to the others. The statutory framework allowing the application, is 165.10.726, and it defines a one-time land application of drilling fluids. And it talks about what that is. The key thing is, under this rule, it falls under the federal regulations under RCRA, the Resource Conservation and Recovery Act. Now, the reason that's so important to you as a surface owner is because under RCRA and under federal law, if you're the landowner and your property becomes polluted, you can be responsible for the cleanup costs. So if you get a big plume there as a result of them coming in and dumping a lot of stuff that they shouldn't be dumping, and they're not solvent and they can't pay for it, the feds may be coming in looking to you for the bill, especially if it's migrating off your property and getting on somebody else. Any land application made under this has to be done on what they call a one-time basis. And, we could talk about one time. It's defined a lot of different ways, and you could talk a lot more about that, Mike, probably than me. But compliance with the rule, there's a $2,000 fine for non-compliance with the rule. Typically, it's a 12-month, it is a 12-month permit. That's what the rule says. Talked earlier about the maximum slope. The application can't be within 50 feet of the property line. The water table can't be within 6 feet. There are somewhat detailed sampling requirements. There's been a lot of discussion tonight about sampling. My recommendation would be, if you're going to do this on a large scale, that you get a geoscientist involved and you come up with some parameters of your own and you put those in your own contract instead of relying on somebody else to enforce them. He talked earlier about the depth to bedrock and the soil texture and the soil salinity, so I'm not going to go into that too much. So, negotiations and the surface use agreement. The key thing about this is an oil company doesn't have the right to do this. If they drill a well on your property, and I think it's already been said, but I just want to be real clear about it, they don't have the right to put the drilling mud on your property. They also don't have the right to take your water. So they do have a right to come and drill the well and use as much surface as is reasonably necessary for their oil and gas operations, but they don't have a right to put this drilling mud on the property. So that gives a surface owner a little bit more negotiating power when negotiating the terms of the contract. I believe it's critical that you have a good contract and you have a good surface use agreement and that the rules of the game are clearly defined and everybody knows what they have a right to do and what they have a right not to do. Mike talked a little bit about the 1014L, which is the landowner form that's presented at the commission. Before you sign the 1014L, you need to have your contract with them completely done. Don't sign the 1014L first and then start trying to negotiate the contract. I think that's a recipe for disaster. A lot of people, it seems at times, don't understand the difference. They think, well, the Corporation Commission will step in and they will take care of me as a surface owner. And they do a lot of good things, and they do a lot of good things for the citizens of the state. But as an individual surface owner, that's really not their job, and they really don't have the resources to completely manage that. And really, as it's defined in the Constitution, they're charged with protecting the public right. They're charged with protecting everybody and keeping all of us safe. But they're not necessarily responsible for our individual property rights. That's not what the Corporation Commission does. That's why these types of contracts and why you need to negotiate with them one-on-one is real important, because if you sign the 1014L and you get in a fight with them later and they're doing something wrong, the Corporation Commission's not going to step in. It's been my experience. They're not going to step in because you're unhappy with something they're doing. It's going to have to be pretty egregious, or they're going to have to be doing something clearly wrong under that other statute. So if you want things outside of that other statute, you're going to need to negotiate that in a contract, and they're not going to enforce it. You're going to have to do that in your local district court should it come to that, but if you have a good contract, it probably won't. We talked a little bit about under RCRA and the federal statutes, the landowner can be held responsible for the pollution on their property. So some considerations to address this. Do what you can, if possible, to make the primary company responsible. Because the next thing I'm going to talk about is indemnification, which basically says if they come in and they make a big mess on your property and somebody else sues you for that, they're going to step into your shoes and they're going to defend you. But if it's just some fly-by-night guy that's out there applying drilling mud, it's not going to do you any good to have that indemnification provision, because whoever's going to bring the case, they're going to go after whoever's got the money. So you want to do what you can to make sure if you're entering into one of these type of contracts, you either make the big oil company that's putting it on the land, you either make them responsible, get them to agree to be responsible, or make sure that the person doing it is really reputable and they've got some assets if there becomes a problem. And you need under the law what's called privity. So if you're dealing with the contractor that's been hired by the big oil company and they say, well, the big oil company has agreed to be responsible, and they write something in there that the big oil company will be responsible, that won't necessarily get you there. You need an authorized representative of the big company to say that they're going to be responsible. So you've really got to make sure that the legal part of that is covered correctly. No middlemen, agents, or independent contractors. If you do deal with an independent contractor, you need to make sure that they're really solvent. And I think that this bond is going to help a lot. That's going to be a good thing when we have a bond similar to what we have in the Surface Damage Act. So you need a strong indemnification provision with some teeth to it. And I believe you need to make the standards stronger than what the standards are that the Corporation Commission has. And that's where it goes back to what I was talking about get your geoscientist involved, get somebody involved that understands the science, and get them to define what acceptable levels of certain chemicals are. Make sure that all the testing, that they agree that whatever testing happens, they will be responsible for it. So you want the contract written in a way where you can request testing and you can request the standards, but they agree to pay for it. Make sure that any testing's done, that all the results are made available to you, and that your contract says that those results will be made available to you so you have a legal right to them. To set specific, more stringent standards, or at least make the contract actionable for violations of the commission statute that I showed you before. So if they come in and it's raining and they spread a bunch of stuff, which they're not supposed to do, make them responsible for it. If they get within 50 foot of the fence line and they apply stuff and they're not supposed to, make it where they're responsible. Put some kind of penalty in there for not following the rules. Make sure in your surface use agreement for sure that you include the application rates and the soil loading rates. And in any time you do one of these agreements, you want to make sure that you put a prevailing party attorney fee provision in there, because the last thing you want to have happen is be in a situation where you're trying to enforce your agreement, but you're getting money whipped by the big oil company because you can't take it to a lawyer and get a lawyer to take the case, because you'd have to pay your own attorney fees, and even if you win, you're not going to get your attorney fees from the other side. But if you have a prevailing party attorney fee provision in your surface use agreement and you're in the right, you're going to get your fees. And you're going to be more likely to find a good lawyer to come in and take your problem. If you're using a middleman to apply it, and really any time you're doing this, you want to have something, if they're generating a report with the amount of loads that they're dumping, you want to have something in the contract that says you have a right as a landowner to see the load tickets and see what's been applied on the property. I mean, it's all about information. So it's not the fact that you will probably ever go look at the load tickets. It's the fact that you have the right to go look at the load tickets that's probably going to hold them more accountable, because they know at any time you can come in and check and make sure that they're being honest about what they're doing. And if you don't have that in there, then probably the only way you could ever get it is if you sue them, and then you just might get it. Make a condition of the agreement that variances to be applied for at the commission require landowner approval. Now, What I mean by variances is the commission rules have certain parameters, like, for instance, one of the commission rules is this is a 12-month permit. Now, I don't know, Mike, if they can go back after 12 months and extend it for 6 months. Okay, Mike's shaking his head yes. So that would be a variance. The rule says 12 months. But if they're at month 11 and they need to make the application for the next 6 or 8 months, what they'll do is they'll go to the commission. They'll ask the commission to give them a variance from the rule. Typically, those are fairly liberally construed. And so the commission will allow them, now instead of it being a 12-month permit, it becomes an 18-month permit. Just what I'm saying here with this is, before they go do that and go to the commission and ask for that variance, make sure that they've got to get your approval before they do that. Have a warranty provision with respect to standards. Have something in there that they say that they warrant, that they will comply, that they will follow all the rules, and that they will be responsible if they don't. Keep identical copies of all executed documents. Always. Got a client right now here in Carter County. He wrote a 5 on there, and they wrote an 8. They just connected the deal. They extended it for 3 months. I mean, it doesn't happen all the time, and probably, I've said this, when you're dealing with my experience being when you're dealing with a bigger, reputable company, they typically don't do things like that, but sometimes they have independent contractors working for them, and sometimes it happens and they don't even know it happens, but it just happens. So always make sure that you keep a copy of everything, because if you don't have a copy, it's real hard to prove that they changed something. A condition of the agreement that the operator provide a copy of the permit, and that they can't put it on your property until they have their permit. So in your surface use agreement, you want a provision in there that as soon as they get approval and they get their permit from the commission, they have to provide you, as a surface owner, a copy. You don't have to go up there and look for it. They have to send it to you. That way you know that the commission's given them permission to put this stuff on your property, and they're not just coming down and doing it without a permit. And it's happened. So clearly, this is the easiest way that I can explain this. Clearly define the what, the when, the where, the why, the how. Like everything you can think about. The number of loads, the amount of time they can be in there, the per unit price, all of those different things, you want to define those in the contract. The number of barrels, which wells allowed. If they're coming in, this is something I see a lot. They come in and they're drilling 4 wells on a surface owner, and they get a permit to soil farm. The surface owner's perception is they're going to soil farm those 4 wells on their property, and they sign for 12 months. And they soil farm those 4 wells. And then they go drill 4 wells on the neighbor. Now they come over to the first guy, and they're soil farming those other 4 wells on his property, and he didn't have any idea that was going to happen. So get them to provide you a list, if possible. It doesn't have to be, but if they're representing to you that it's only going to be a few wells, get them to provide you the names of the wells that they're going to dispose from. That way, if they come back and they want to dispose from a different well, you may be okay with that, but it may be a real good opportunity for you to get some more money. The unit price for application, I recommend tying everything to a unit and then a price per unit. A time frame that the application will be allowed, I've kind of already said that. So wrapping up with respect to a surface use agreement, you need to have a provision that dictates when they no longer have an application right to put it on your property. An end of time for them to apply it. Now that's different than an end of time for them being allowed to come to your property. It's the end of time for them to be able to apply drilling mud, because as both of our previous speakers have kind of spoke to, the relationship, if done properly, doesn't end when they quit putting mud on your property. I mean, when it ends is when your Bermuda grass starts growing like it did before they came, or pretty close to it. Put a provision in there that they can't leave stuff out on your property for so many days after they've been done. I usually put 30 days in there. It's unbelievable how they'll get you to sign something and all at once they'll turn it into a storage facility. I mean, I see it a lot more on locations. They'll put a location on somebody, they'll be fracking a well down the road, and they'll use that well as a staging area for frac wells. And there's nothing wrong with that, but I've got clients that get paid several $100s a day for allowing them to stage wells on their property. So you might as well have something in there so that when they do that, you can get some money. Then you also want to have a time in there where they no longer have a right to be on the property after they've complied with your remediation provisions. The OCC language is a bona fide effort to reestablish within 180 days. To me, that's a little bit of a hard, standard to define. I would prefer to get an agronomist or somebody like Ed.D. involved and get them to kind of come up with some standards and say, these are the standards you're going to meet, and when you've met that, we'll consider it remediated. Talk a little bit about remediation. This is a typical remediation provision, and what it says, and I'll just read it, I guess, but it says, any disturbed areas shall be ripped and recontoured to conform with existing grade. Topsoil shall be provided if erosion occurs to place lands in a condition to their state prior to said application of drilling mud. The disturbed areas should be revegetated utilizing a seed mixture, application rate, timing, and reseeding method approved by the owner if after 1 year from planting vegetation comparable to the original condition of the site is not established. Such reseeding shall be continued annually until such vegetation is established. Foreign substances and unnecessary equipment shall be removed from each disturbed area, and erosion shall be adequately controlled, and if erosion occurs, it shall be halted and fully remediated. To me, that type of language is a lot stronger and a lot better than a bona fide effort. And I realize the Corporation Commission rule book is already really, really thick, but what I'm saying is, as a private landowner, you need to be specific like this, because the more specific you are, it doesn't mean that they have to do all these things just because your contract says it. It just means that if you're not happy about what happened, you've got a little bit more leverage. So, closing thoughts, and this is in general. It's not just in drilling mud. I mean, it's in, pipeline negotiations, water negotiations, drill site negotiations, any type of those negotiations. Generally, when dealing with an operator, nothing in writing is better than having something bad in writing. The guy that shows up at your door with the one page and says, well, this is just our simple one-page agreement. This says all claims of every kind and character, whether unknown or known, from now until the end of time. It's real simple. You sign it and you give up all your rights, and now they got all the sticks. So you're better off to have a long agreement that's real specific and clearly defines something than signing something like that. Use clearly defined terms and the tightening down of overly broad terms as an opportunity to get more money. And information is the best offense to getting the best deal. Well, I appreciate everybody's patience and attendance. Okay.